Any mention?
May it pleases your lordship. My lord, item number 4, 6 and 7, my lord, these are connected matters. The state council, my lord, the state is being led by Mr. N.D. Shulai, my lord. He, due to his personal difficulty, my lord, I'm praying that this matter may be posted on some other occasion, my lord. There's a bereavement in the family, my lord. He has gone to attend the funeral, my lord.
4.
My lord, 4, 5, 6 and 7 appears to be connected matters, though Mr. Shulai is in 4, 6 and 7.
4, 5, 6, 7.
My lord.
So, what the
Lordship, I appear in item number 4 and 6, Your Lordship.
I mean item number 7, madam.
you're in 7.
6. I am also in 6, my lord.
Oh, he's in
5.
item 5.
Mr. Yobin is in 5.
Oh, 5. 6 also is there, my lord. 5 and 6. But in item number 5, my lord, I am not seeking adjournment. And then this is a matter, my lord, it's a salary matter, my lord. It's been over 2 or 3 years. I've been teaching, salary has been paid, and the government is blaming each other. Government is blaming the managing committee. Managing committee is pushing back to the government. And in the meantime, I continue to serve, continue to teach, my lord. Of course, in the other connected matters, item number 6 and item number 4, my lord, there is a challenge to our appointment. But then there is no stay, my lord, no stay operating. So our services have not been served. Pursuant to that, we have been serving, my lord. And the salaries are not.
Okay, so we'll. How long then? 1 week.
My lord, Mr. Yobin's matter is number 5.
No.
And this one, if at all he is...
If they are all connected, then.
Lordship, it concerns the same school because we
Same
had challenged
school,
their
same
appointment. We had challenged their appointment itself. So, Your Lordship might as well heard the matter finally, Your Lordship.
A week's time, my lord, next week.
So, week's time?
A week's time, Lordship.
1 week only, my lord. Only 1 week, my lord, not more than that, my lord.
On pre-made by Ms. Arkulni Leonard, seeking accommodation on the ground of indisposition, on the ground that the Leonard AAG, Mr. N.D. Shulai, is indisposed due to personal difficulties. Matter is adjourned. This is him after 1 week. 4, 5, 6 and 7.
My lord.
1 week.
My lord. All right, my lord.
Lordship, I'm mentioning item 14 and 15, Lordship. 14 and 15. This is a joint prayer, Lordship. 14 and 15. Mr. Chanda matters. After a week, Lordship.
On pre-made by Mr. M.L. Lupur and a council petitioner.
It's a joint prayer, Lordship.
On pre-made by parties, this is matter after 2 weeks.
Obliged.
Please, Lordship. I'd like to mention item number 16, Lordship. Mr. Shila is unavailable today, Lordship. Kindly give us 2 weeks' time for hearing. 16? 16.
On pre-made by the appellant, this is matter after 3 weeks.
Obliged.
Please, Your Lordship. My lord, I beg to mention item number 12. Again, the similar problem. Lordship will kindly see the order dated, my lord. 3-9. This was posted by before. It was before my lord's justice. Thank you, my lord. After hearing my lord substantial hearing, we concluded our part on maintainability. Then it was posted for further hearing. Their order is there. Item number 12.
12.
Yes. So my lord, it has to go back. Like other matters, lordship is referring to the chief
Yeah,
justice.
there.
Lordship, my senior is on deck.
Huh?
My senior is on deck, Lordship.
A bit louder, I can't hear.
Lordship, my senior is on deck.
It doesn't matter. So we'll pass a similar order.
She says her seniority is on lag.
Yeah.
Might be in some other court. But that is only my submission. It's not the question of our agreement, my lord. It's the question of 58, what I pointed out, Rule 58 of the High Court rules. If it is part heard, unless there is a specific order regarding this, and that's what my lord is doing. So, this 12.
Yes.
So, my lord, lordship will see
Mr.
that
Day.
order, particular order, my lord. If necessary, I'll just read it out.
Mr. Day is there.
Yes, I'm the petitioner, my
This
lord.
is the petition.
Okay.
What has come, my lord?
No, this matter will be taken up by the bench which has taken up this matter earlier.
But this matter has been. They have not said it is a part hard matter, my lord.
My lord,
they
will
have
see,
never
my
said.
lord.
They have never said.
3/9/2025.
I don't know why they want to go for.
No. Lease this matter on 10th February for further
Further
hearing.
hearing.
Further hearing.
My lord.
And
in
substantial
many
order.
orders-
Substantial order is 10/9/25. I'm reading. On this request of E-Docker Learned Counsel for the petitioner, let this matter. It is noted that since the matter has been substantially heard. What more, your lordship? What
If
more,
my
my
lord
lord?
senior want to do window shopping, I have no issue, my
This
lord.
should not be. My lord, first they should answer what is this 58 High Court rules. We should have some respect for High Court rules.
My lord, we are not saying whether we have a respect or not, my
It's
lord.
not
That
the
is
question
not.
of
That is
window
not.
shopping. Will
there,
your
my
lordship
lord.
allow
On the
window
last
shopping?
occasion also, my lord, on the last occasion also, this was pointed out, and my lord has said that my lord will clarify, and then the matter was listed again before my lord. Now, if they have a reservation for this, my lord,
Substantially heard, my lord.
See,
Negotiate that
see,
point, my
Mr.
lord.
Day, the
I have no
clarification is
problem.
this.
my lord.
If now the ball is in your court. In as much as if the parties agree
My lord.
the matter to be released, then it will be released.
No, my lord. My
But
submission
if
is
you
that-
agree that the matter will
No,
be
my
taken up
lord.
with this court,
My,
it's up to
no,
you.
no, my lord. My submission is this. By an agreement, my lord, we cannot take out this matter before any other court, my lord. We will have to go by the High Court Rules 58. If the matter is tied up matter, that has to go before the same court, unless there is a specific order that it is being released. That's what the law says. It's not the question of my agreement. It's not the question of his agreement.
Even
It's the question of law, my lord. The procedural law laid down in the High Court Rules 58. Nothing else.
What has
We
fallen
do not
on
have
the-
choice, my lord,
on
to
the
take
last
court somewhere
occasion-
else.
On the last occasion, what has fallen from my lord, that my lord will clarify.
yes, that rule. You see what Mr. Sen said.
lord.
Rule 58 is there, except that there is no specific order by the previous court or by the coordinate bench that this matter will be
Exactly, man.
referred.
What I
But-
can understand, my lord,
but-
with my little knowledge, my lord, what I can understand, my lord, when the matter is kept part hard, my lord, an order is reflected, and it is also reflected in the cost list.
Exactly.
That has not been done, my lord, here.
That is not done. But you see, what if I can recall just now what has been read out is
Substantially heard.
a certain order has noted that matter has been substantially heard.
And it was heard, in fact, my
and
lord. I appeared.
And hearing will
They
come.
appeared.
So it,
I don't know why
it's a-
my
it's
learned
a- it's a-
senior has some difficulty.
you see, it's a question of convenience.
It's not the question of, again, difficulty. It's not the question of, my lord, window shopping. These are all very responsible submission. It's purely question of 58, my lord. As a lawyer, my lord, it is our abundant duty to see, my lord, these procedural laws of the High Court are enforced, my lord. And that is what I am pointing out. Nothing else, my lord. If your lordship feel, my lord, that 58 can be circumvented, I have nothing more to say. It's very clear unless there is a specific order in
When
matter.
there is a roster, my lord, fixed by the Honorable Chief Justice, my lord, he has probably taken care of this also, my lord.
But if it is there in the order, I have nothing to say. There is nothing, my lord, in the order regarding, my lord, part heard matters.
and there is nothing in the order also that has been declared as a part hard, my lord.
It
This
says
matter.
substantially heard.
My lord,
Substantially heard.
there are a number of orders, my lord. Similar kind of order is passed, my lord. Then again, my lord, the matter goes to other court, my lord. There is nothing, my lord, that I have no reservation that I have to do it in this court. But what has fallen and why they are hell bent to take this matter?
That's not the premise.
It's not question of,
No,
it's
but
purely question of
my
law.
understanding is this, my lord.
Yes,
I have
Mr.
no issue, my lord.
Yeah, Mr.
Only thing is this, my lord.
Just submit. The case may be part heard when the bench heard the matter expressly mentioned that the case is part heard. Number one. Number two, my lord, if the case is substantially heard, it is not necessary to express in the order it is part heard, my lord. Therefore, that we are trying to say. In this case, my lord, we have advanced all the argument. Only my learned esteemed friend is supposed to give his reply only. All the three respondents has been heard already.
You have
And
also
he
been
sought
heard.
time on
I'm for the
that day.
petitioner, my lord. Where, my lord?
May I just complete, with due respect. He sought time to give his reply, so matter was deferred, subsequently roster changed. Now only may I clarify, the reason why we cannot say that on our agreement, matter can be referred back, that give a wrong message. That amounts to shopping on bench. Therefore, our duty of surprise, the rule is very clear. And my friend is not disputing that it is substantially heard. It is his duty to give his reply only. If Lordship take up the matter now, everything will be heard again. Therefore, only his duty is to give reply. So it is a fit case, appropriate that it can be reverted back to the other bench, first bench. Other, we have no other reservation, but it is our duty to apprise this position.
My lord,
It may be
with due respect to my
reverted
lord,
back.
senior my lord, the matter was heard only on maintainability. I was supposed to reply, but the matter has come here, my lord, again in a coordinate bench. It's not that, my lord, some bench is senior or some bench is junior. It's a coordinate branch, my lord. When the matter is not kept as a part heard, this is my understanding, my lord. I am open to be corrected by my lord seniors, my lord. When the matter has not been declared or ordered as a part heard, my lord, by saying that it was heard, my lord, it doesn't mean that, my lord, it is a part heard. This is my understanding, my lord. I may be totally wrong. The seniors are there much more, my lord,
See, Mr. D,
in a better position to.
Mr. Sen, you show me that order.
Yes. My lord, part heard is not required to be mentioned. Whether lordship the court is in the middle of the hearing, that is good enough.
I think the words substantially heard.
It's the middle of the hearing, my lord. What is? It's not part heard. That day, my lord, I point out, it is the job of the registry. They may note in the file part heard, write it. So ensure that change of a roster will not automatically lead to the transfer unless it is released. So it's not a question, my lord, that, my lord, I feel more privileged in one court. It's not that, my lord. Only thing, my lord, I am, my lord, pointing out 58.
See, Mr. D, I'll just give you an example.
No, my lord, I have no reservation. If my lord want to release this, I have no
I'll
reservation.
give you an example. There was a matter that was listed before the division bench, headed by the Honorable Chief Justice. He went through the records, found out that in
Division bench matter.
in the order, that is a division bench matter. In the order, there was some initial order passed by a different bench where stay was granted or something. Immediately he said, no, since the other bench has passed the stay order, so this matter may as well be heard by that bench. There was no order that this will be a part heard matter. But that was the wisdom of the bench then. So even on that ground also, matter was released, and that bench will take out the matter. So so we don't have to go to the technicality of it. It is, as I said again, it's a question of convenience for the parties.
Even our case, my lord, was sitting in the division bench, amend of assignment, that review application. The original court was not available. Somehow lordship has taken up, my lord. Now, because of the new Chief Justice took over, matter was transferred to the new Chief Justice. He just went through the record and said, this at one point of time, review was taken up by the other bench. It was sent back, and ultimately lordship, along with my lord Justice Bhattacharya, heard the matter and passed the judge. And here, my lord, I am concerned with 58, nothing else. Because if these are relaxed like this, my lord, nothing remains in High Court rules.
Okay.
Oblige your lordship.
Heard letter also for the parties. Mr. Sen, letter standing counsel for respondent 1 to 4 has pointed out that this matter was earlier taken up by a coordinate bench of this court, whereby by the order dated 10/9/2025, the said court has noted that the matter has been substantially heard, which implies that the concluding hearing will be taken up by that court. In the meantime, because of change of the roster, this matter was listed before this court. However, it is the submission of the learned of Mr. Sen that since the matter has been substantially heard by the coordinate bench of this court, it would be prudent for this matter to be released by this court. Mr. S.D., counsel for the petitioner, on the other hand, has objected to the preamble on the ground that there is no specific order by the coordinate bench that the matter has been kept as part heard. As such, according to him, there is no impediment for this court to take up this matter. This court has considered the submission made and has also noted the set order dated 10/9/2025 supra. In the opinion of this court, since the matter has been substantially heard by the coordinate bench of this court, it would be convenient for the same to be finally heard by the said court if otherwise if there is no contrary order to this effect. Atau coordinate bench I have an bracket HS. Accordingly, this matter is released from this court, placed the same before Honorable the Chief Justice for on the administrative side for necessary orders.
My lord. Hello, this.
Chief Justice he may refer the matter back to this court.
Yes, my lord. Let him decide.
My lord, that's that boy. Yes,
My lord.
that's a different thing.
My lord,
That
senior
I
will have
don't
no
know.
objection, my lord.
No, how can I?
You take this. We'll keep this in the file.
Quiet.
No, we'll keep this in the file. But it's already there in that.
It is
all.
I know.
Whatever you do.
Keep it. To mention item number 13, Your Lordship.
Yes.
Item number 13, Your Lordship, I beg to mention item number 13. Praying for 2 weeks' time, Your Lordship.
You are for?
For the state, Your Lordship.
State.
State respondent.
What is your ground?
Just need time to prepare, Your Lordship.
No objection, Your Lordship.
Mr. Leonard G has sought for accommodation on the ground that he is not prepared to be heard on this matter today. Ms. Leonard Counsel appearing for the appellant has no objection to the prayer made. Accordingly, place this matter after 2 weeks.
Lordship, similar prayer for item number 1.
Item number?
Item number 1, Your Lordship. On behalf of S.N. Gupta, Your Lordship.
No adjournment.
Is indisposed today, Your Lordship.
Huh?
Is indisposed today.
Whatever. We'll hear the petitioner. I think I've made it clear in this matter. If any party seeks adjournment, if adjournment is granted, you'll be imposed with heavy costs. Up to you. Yes. Anything else?
Your Lordship, I beg to mention item number 10. 2 weeks' time, Your Lordship.
Yes, what is this matter about?
This is service matter, Your Lordship.
Service matter, if you delay, see, if the petitioner is to receive any benefit, then
as per, it is not a promotion per se, my lord. But here, my lord, I have been appointed as the MD, my lord, managing director. And there are several criteria for the, my lord, for the appointment to the post of managing director, my lord. Now, he is claiming that he is senior, but that is not the case, my lord.
Okay. Is appointment for the position of MD by by promotion or by nomination?
My lord, what normally happens is that the criteria, the curriculum vitae is sent to the government, my lord, then they take a decision. Now there are examples also where people from other departments have also come and occupied that position, my lord. That is the case.
On plea made by Mr. Counsel for Petitioner, let's this matter after 2 weeks.
Obliged, my lord.
Supplementary list, item number 1.
flashing gini macam case ke baik. Yes.
Sure. If I may pray, my lord, if the matter can be taken up tomorrow, my lord.
Why?
Since respondent also is not here, my lord, and Mr. Paul is also not here today, my lord. Can be taken up tomorrow, my lord.
Look at the
My lord,
last
my lord,
order.
I've seen the last order, my lord.
And this is also, you see, this is also an agreed deal.
My lord, it's agreed by both the parties. My lord.
It is not that this court has imposed on you. Both of you have agreed. I mean, both parties, or rather all the parties.
Tomorrow, my lord, my lord.
When this matter came up for hearing, Mr. Laird G.A. has made a prayer for accommodation on behalf of Mr. S. Sengupta, Laird Additional Senior G.A., who is conducting the matter on the ground of his indisposition due to personal difficulties, for which he could not appear in court today. Similar prayer is made by Ms. Adata, the counsel for the petitioner, also on the ground that the Learned Senior Counsel, Mr. K. Paul, who is conducting the matter, being indisposed. Next, this court in its previous order dated 3/11/2025 has made it clear that no further adjournment to be allowed. And the order also reflects that both the parties have agreed that this matter is to be heard today. However, since both parties have sought for accommodation, the prayer made is allowed on condition that both parties are to pay a cost of 1,000 each. The same payable in favor of the High Court Bar Association towards the fund for procurement of books for the said association. Matter to be heard on the next date on the parties' production on the parties upon the parties producing the receipt of payment of the said cost. We'll have it on 19. This is matter. Again, I'll have to write again as agreed to by parties. As agreed to by the parties, this is matter for the hearing on for hearing on 19.
Item number 2.
But, Your Lordships, have heard this matter at length, and I had completed my arguments, and the state has also replied. So now I have to only give my rejoinder. So just to recapitulate, this is that matter where the petitioner was not considered for promotion. He was not considered for promotion, and in violation of the rules, without recording any reasoning, his juniors have been promoted and he stands superseded. So that was my stand, my lord, and I had also pointed out the rules. And in reply, the state has stressed on the point of delay. Now, before concluding my arguments, my lord, I had cited one judgment of the constitutional bench of 5 judges, my lord, which my lord lays down that right to be considered for promotion is a fundamental right. Right to be considered, my lord. So that was one judgment. So today, my lord, in rejoinder, I will only place a few judgments, my lord, and I'll just keep it very short. Before I place the first set of judgment, which is also a constitutional bench judgment, I'll again take your lordships to the rule, one particular rule, which your lordship will find at the rules. It starts at page 31 and extra 7, my lord. Page 31, Annex 7 is the rules, my lord, the Meghalaya Agriculture Service Rules 1996, and I'll take your lordships to Rule 9 at page 32. Rule 9.
Yes.
Rule 9, my lord. Then I'll take your lordships to sub-rule 3 of Rule 9, which is on the next page, sub-rule 3. On the next page.
Yeah.
The rule reads, my lord, the names of the persons in the list shall be placed in order of preference for promotion. In every case where a junior member is selected in preference to his senior, the committee shall record in writing the reasons for doing so. So, this is my case, my lord. Now, on this, my lord, I will cite a judgment, my lord, which is a constitutional bench judgment, my lord. Famous judgment of A.R. Antule, my lord. This is a 5-judge bench judgment.
What is the citation?
My lord, this is reported in 1984.
Okay.
1984, volume 2, Supreme Court cases, page 500, 500, my lord.
Yes.
So, my lord, I'm relying on paragraph 22, which your lordships will find at internal page 523. Page 523, my lord.
Yes.
Para 22, my lord, middle of the page, I've highlighted also, my lord. Just the my lord, principle. It is unnecessary to refer a long line of decisions commencing from Taylor versus Taylor, Nazir Ahmed versus King Emperor, and ending with Chitiam Vettel Ahmed Taluk Land Board, laying down hitherto uncontroverted legal principle that where a statute requires to do a certain thing in a certain way, the thing must be done in that way or not at all. Other methods of performance are necessarily forbidden. So, my lord, I'm relying on this principle because, my lord, if the rules provide, my lord, that reasonings have to be recorded. Now, nowhere in the counter have they brought out anything to show that yes, we have considered the petitioner, but for so and so reasons, we have not promoted him, my lord. This is one judgment, my lord. The second judgment is, my lord, reported in 1986.
See, Mr. Nobu,
Yes.
at the time of consideration for the promotion, when your junior was supposedly,
Not forwarded.
taken to
Consideration.
account for promotion,
Yes.
your name also figures there.
No, my lord. That is the case. And they have nowhere shown from their reply that we have considered him and for so and so reasons, we have not my lord, recommended for his promotion. Nothing on record. So, my lord,
Only if I recollect,
yes,
only on the ground that he was not in station or he was posted somewhere outside. Is it so?
No, my lord. They have said that he absented himself from service from duty, my lord, for a certain period. Now there's no DP to that effect. No DP, no show cause, my lord. Only now in the reply that they have come up with something like that. But there's no show cause, no disciplinary proceedings.
Not reflected in ECR.
No, my lord. So, my lord, the next judgment is on the same principle, which is reported, my lord, in 1986, Volume 4, Supreme Court Cases, page number 326. This is in the case of A.K. Roy and another, my lord. Same principle, my lord. I'm relying on paragraph 10, my lord. Paragraph 10, my lord, starts at page 332, internal page 332. And the portion I'm relying, my lord, will find at page 333, which I have highlighted. I'll just read the highlighted part, my lord. Page 333. That conclusion of ours must necessarily follow from the well-known rule of construction of inference to be drawn from the negative language used in a statute stated by Treatise on Statute Law, 6th edition, page 263, in his own terse language. If the requirements of a statute which prescribes the manner in which something is to be done are expressed in negative language, that is to say that if the statute enacts that it shall be done in such a manner and in no other manner, it has been laid down that those requirements are in all cases absolute, and that neglect to attend to them will invalidate the whole proceedings. Emphasis supplied. Where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all. Other modes of performance are necessarily forbidden. The intention of the legislatures enacted under section so and so was to confer a power on the authorities specified therein, with power have to be expressed in a manner provided and not otherwise. So, these two judgments are to support my case on the point that the service rules provide that in case a junior supersedes a senior, then there has to be a recording of reasons, which has not been done, my lord. So, my lord, on the basis of these judgments, anything that is not done as per what the rules provide, my lord, that is totally forbidden, and, my lord, as good as void, my lord. Now, the third judgment that I will just point out, your lordships, is on the ground, on notional promotion, because during the arguments of the state, my lord, certain questions were posed whether this honorable court can issue a mandamus or no, my lord, or whether this court should issue a mandamus. So I'll just, my lord, hand over a judgment. This is reported in 1974, Volume 4, Supreme Court Cases, page 308, State of Mysore, my lord. I'll straight away take your lordships to para 5.
Yes.
Page 311, internal page, para 5, where it reads, my lord, in State of Mysore versus Syed Mahmood, Justice Bachawat, speaking for the court, held in case where the promotion of an officer was involved, that the proper direction should be that the state government should consider. So this was what I had submitted on the last occasion also. Your lordships will not say promote, your lordships will say consider. Should consider the fitness of so and so for promotion in 1959. So this is what I am asking for, my lord, that a direction from this court to the state government, my lord, to consider my fitness at that point in time. It further reads, my lord, the state government would upon such consideration be under a duty to promote them as from so and so if they were then fit to discharge the duties of the higher post, and if it fails to perform its duty, the court may direct it to promote them from 1959. The court concluded in that case thus, we direct that the state government to consider whether so and so should have been promoted to the post of senior statistical assistant on the relevant dates when officers junior to them were promoted, and if so, what consequential monetary benefits should be allowed to them. So this is what I am submitting, my lord. Your lordships will not say promoted. Your lordships will say consider if he was found fit when his juniors were promoted. It is for them to consider, my lord. Para 6, my lord. Similarly, in state of Mysore versus PN Najumudia, Justice Ramaswamy, speaking for the court, dealt with this service dispute and while agreeing with the substantive conclusion of the High Court, modified the order insofar as the promotion was ordered by the court. The learned judge observes so and so, my lord. Now, I will not trouble your lordship here. I will straight take your lordships to para 8. It further reads, my lord, at para 8, the length of this litigation has really disappointed the petitioner by denying him the enjoyment of likely promotion. He retired the day before the judgment of the High Court. No one in service would be affected by the allowance of the petitioner's claim, and what was a service issue has now been reduced to one of monetary payment. This is also exactly my case, my lord. In this case, I have retired, nobody will be affected. Now it's only a question of monetary payment. And on the last occasion, I had also submitted, my lord, that I am not claiming for areas and pay, my lord. All I am claiming for is, my lord, my promotion may be considered. If my suitability is considered, and then if I am promoted, my lord, notional promotion be given, and my pay may be fixed, my lord, which will help me in my, my lord, final pension, my lord. Now, my lord, the next judgment is what was relied by my learned friend in the case of O.P. Gupta. Last time my learned friend had handed over. You relied, no? O.P. Gupta. My lord, it's reported in 1996, volume 7, Supreme Court cases, page 533. Yeah, that's what. This is 1996, my lord.
It's a state of Haryana versus O.P. Gupta, my lord.
Haryana versus S.K. Khosla.
O.P. Gupta. 96, volume 7, 533.
My lord, I'll just hand over.
Yes, it is.
So, my lord, I'll take your lordship straight away to para 7 of this judgment.
I think you have cited this judgment.
Yes, it was cited. I'll just point out one particular line and then I will conclude, my lord.
Yes.
What was contended by my learned friend that areas cannot be paid because there can be no pay for no work, my lord. But I am also relying on this judgment, my lord, especially para 7 for one particular part, my lord. Para 7 reads, my lord, this court in so and so considered the direction issued by the High Court and upheld that there has to be no pay for no work. That is, a person will not be entitled to any pay and allowance during the period for which he did not perform the duties of higher post, although after due consideration he was given a proper place in gradation list, having been deemed to be promoted to the higher post with effect from the date his junior was promoted. So this is my similar case, my lord. Now what I am relying upon is the next line, my lord. He will be entitled only to set up the scale of pay retrospectively. So this is what I'm asking for. The setup of my pay scale should be retrospective from the deemed date, but not entitled to payment of areas of the salary. So, my lord, I have already made a submission, my lord, that I'm not claiming for areas. All I'm claiming for is, my lord, consideration of my notional promotion from the date with effect from when my juniors were promoted, and my scale of pay, my lord, may be my lord, set up as per, retrospectively, which will benefit me, my lord, in my pension, my lord. That is my submission, my lord.
So I've sufficiently addressed those points, my lord. In fact, OP Gupta, I had to light one. If lordships permit, if any notes are required, we can supply it notes, my lord.
Okay. When you file your written argument,
My lord.
Mr. General Counsel for the petitioner, hearing is concluded. However, the General Counsel has submitted that they may be allowed to file written argument in this case. Accordingly, this is matter after 1 week.
Obliged, my lord.
Item number 3.
My first appeal against the order passed by the Special Court, Land Acquisition Act. I finished my argument, my friend has finished. And in fact, today is fixed for argument from the collector.
Who is appearing?
Learned AAG was representing earlier occasions.
This is the fourth time they've been.
Who was there?
Learned
Mr.
AAG, Mr. Shulai used to appear for collector.
Mr. Shulai today is indisposed.
All right.
He had some
Yes, one of his relatives passed away.
bereavement in his family.
Well, the conducting counsel want to make some submission. Can you have it at the end of the board? Courtroom one is
Since the matter is posted only for the collector to make his submission.
Yes, this is the fifth time, if I'm not mistaken.
No doubt. But what to do?
Can you have at the end of the board, Lordship, the meantime
Today
that
he is
the
not
other matter
here.
come up?
Even if any submission is made by any of the parties, without his presence, then it will not be.
Subject to my not convenient, matter will be deferred to next week.
Positively, my lord, because it has been
No,
going on.
we'll hear definitely next week. It's a long pending matter. It cannot be. Matter is adjourned on the ground that the learned AAG, Mr. Andy Shulai, appearing for the collector, being indisposed on grounds of personal difficulties. This is matter after 1 week.
Obliged, Lordship.
Item number 9.
My lord, this is a challenge to a dismissal of service. Now, my lord, before I start this matter, I have one difficulty today. Now, my lord, here what has happened is the person, a follower in the serving in the police force, was removed from service by applying the rules that normally would apply to police personnel. The rules.
So a follower is distinguished from
Yes,
police
yes,
duty.
Yes, ma'am. He does not come within the meaning of a
policeman.
Of a policeman, because the police manual recognizes two types of policemen. One is the military police, and the other is the district police. Now it says that the district police is further classified into two parts. One is the gazetted police and the other is non-gazetted. Now in the category of non-gazetted comes sergeant majors, inspectors, sergeants, sub-inspectors, assistant sub-inspector, head constable and constable. So follower nowhere comes. Well, the follower basically is kind of a person who is appointed to do miscellaneous ministerial work in the police establishments. So the police rules, the rules which apply to police personnel does not apply. In this case, what has happened is a follower was removed from service by applying the police manual, which of course will not apply. In other words, my lord, the wrong service rules were applied here. These set of rules are meant only for police personnel, not for followers.
What are the rules for the followers then?
My lord, that is the entire confusion here, my lord. There are no set rules, my lord. There are no set rules which would apply to followers, my lord. Now when this appeal was filed, the file was put up before the learned Advocate General also. It is there, he also has said that no, followers do not come within the purview of the police manual. So these rules do not apply. So in this case, my lord, I am little handicapped in this matter today. So if my lord will kindly give me some time to address this particular issue.
Yes, lordship, time may be given since they are requiring some.
Because you see, there must be some rules applicable.
Yeah. My lord, normally what happens in the absence of rule, what applies is the rules of natural justice. The principles of natural justice will apply.
This
but
rule,
if
you cannot put service rules in that category.
So therefore, my lord,
there has to be some. You see, there has to be some.
Yes, my lord.
Do's and don'ts.
There has to be, my lord, and otherwise also, my lord. The other part of the argument is if the service rules do not apply to me, these rules do not apply to me, I cannot be penalized using these rules.
And you can also be given benefit.
Yes, I cannot be given benefit of these rules. I cannot be penalized also.
The rules.
So I'm little handicapped in this issue. If
you see, I don't think the authorities would be so foolish as to exclude them from the purview of the relevant rules. But then
I have gone through the length and breadth of the rules. Lord, it only classifies the nomenclature of police is classified as the military police and the civil police force. The civil police force consists of the district police, the railway police, river police, the CID, and they are further classified as gazetted officers. The rank of superintendent, the rank of deputy superintendent and above, and then the non-gazetted officers.
Are they made to wear uniforms?
No. Followers are not required to do that.
Actually, we have a copy of the departmental proceedings which has been carried out. We have it for your lordship's perusal.
Have you filed that in your affidavit?
Not in the affidavit, your lordship. Yes.
Have you referred to these proceedings or these rules in your affidavit?
Lordship, because the main contention of the petitioner is that the departmental proceedings were not carried out.
Okay.
It
So,
is
Your Lordship, we have called for the proceedings which are carried out, the departmental proceedings accordingly.
so our contention is that the entire is flawed because the set of rules that should apply to me was not applied. I was penalized and proceeded against under a different set of rules. So if my lord is kindly pleased to allow me some time.
How long?
Or kindly give me about 2 weeks time. In the meantime, I'll come up with.
On premier by Mr. C. Gautam Nair, counsel for the petitioner. This is matter to 2 weeks.
2 weeks.
All right.
Second call, item number 2. Item number 3.
Well, on this case, I'm challenging the impugned